in Pasay was to go and fight. They thought Karamojong would finish the war. But unfortunately, the misfortune really happened. That they ended the war, they were not prepared. So I thought in the process, unknowingly they became soldiers. Yes, unknowingly they became soldiers. So I thought if we are talking about this kind of thing, and also the other type of veterans, maybe we'll first discuss with UPDF. We have several veterans all of the war. Like in our village, we have the vigilantes who were recruited, who fought, some of them lost their lives, to bring peace in this country, like our colleagues did. I thought that's another team that we need to look at, really. So I think that I thank the spirit, I appreciate the spirit of this bill. I think, comrade, these are our brothers and sisters who put their lives in the line of fire. I think they did a lot for us. No matter what happened, Abdallah, I want to beg you to listen to these people, because Abdallah was even advising me that why are we...
Okay, now, Honorable
Chair, as the Uganda People's Defense Forces, we really do appreciate the role played by the veterans in the liberation of this country. From the presentation of the veterans here, it's really about enhancement of their pension. How can the bill address the plight of veterans who were retired during that REEF exercise, what we're calling the reduction of forces between 1992 and 1995? Because as you can see, this was just a period of between 6 and 9 years in service, that is since 1986. So even they could not benefit from gratuity because they had not served what we call the reckonable years of service, continuous service. So they could not be entitled to gratuity, and the pension was computed on the basis of the salary they were getting then. The salary was very, very small, so which means in effect that the pension you get at the end of the day is also small. Now, what is being provided here is what would happen, what pension would they get in case there is a similar exercise. But the question is, would this work retrospectively to handle the plight of people who retire?
On this issue, provide their memoranda which has been presented, and specifically on 2.0, where they are claiming having joined the struggle voluntarily to save the country from dictators, and they are not receiving salary. Chair, my simple and brief submission on this, I don't have kind words for my fathers here, because true, they might have saved us from dictators, but if they are to assess where we came from and where we are, I hear these days calling the current regime also full of dictators. So I don't know whether they are proud of where they came and where we came from and where we are. And the only way, please prevail. I'm here. My submission is the only way to prevent further problems for this country is to not even consider these people's submission here. Otherwise, other people will come and join the struggle, pretending that they are fighting the dictators and create more problems. Thank you.
They have a right to be proud, and rightly so, because they really did a good job for the country. The rest is not theirs, it's for you, the politician. The rest is for you, for them. They did their work. And that's what they are saying. They did their work and they are proud about it.
These people have come here because they are on record. They are known people in the system of government earning 3,000 shillings. That's why they are struggling to come here. They are not just a batch of people outside, just there. This is what brings them to come here.
So let's finally have Honorable Katuntu on this matter.
How the MPs debate. Some of us, we are not politicians, but I wanted to maybe request my Honorable, who is near Honorable Fox. He was comparing us with Karamajongs. Really, for us, even someone was saying that comparing our regime with those dictators, something like that. I wanted to request that you understand us and our request. For us, we took our arms and we fought and we won. If they also win, they will also ask for the same privileges.
I like that. End it at that. That's enough. Actually, I wanted to say it, but you have said it. When they finally win, they will also be proud of their struggle. Let us have Honorable Katuntu and
I think we need to look at the objective policy principles of this bill. Among others is to provide for the welfare and pension of the serving officers and also those who have served in the past. However, like any other law takes effect from the day it is assented to, unless we have a retrospective effect or clause. Legally, is it possible? Yes, it is possible. James, it is possible to have a retrospective clause that can cater for categories like his. I am not so sure that I'll address my mind to what my colleague there is talking about, of the rustlers. Then they are going to get free animals. So then we are legislating to provide pension for such categories. Really, I'm not going to be in company of that. I'm not going to be. But people who were really employed by this government, they took over and they continue serving as NRA or UP. Actually, this was NRA, I guess. NRA officers. To imagine that they are getting 3,000 shillings. Do they take that 3,000? Is it put on your account? So even you pick it in the cash. If it goes to an account, it will be wiped out by banker charges. If they say pick it, the transfer to pick it is more than. So it doesn't make a legal, neither does it make a common sense. And our colleagues from the UPDF who are with us in Parliament, this is a very, very serious matter, James and General Edward. You need to go back in-house and urgently address this problem. We don't want to hear these sort of stories, really. It's painful. It's really painful. So, can we agree, Chair? First of all, this should have been an internal discussion on how we are going to handle it. We've listened to their plight, and I think we all agree in principle, save for my brother Abdallah, that these categories should be catered for in this law. Leaving it to regulations, I think there is a problem there. Because regulations are supposed to be implementing the principles in the parent law. So unless we have a provision specified looking at a retrospective effect, the regulations cannot cater for this. So at the time of writing a report, we need to move specific amendment, which we can do legally, which can cater for this kind of veterans. Otherwise, we all sympathize with the situation. And I think we commit ourselves to handle it, Mr. Chairman, to them.
Thank you. That brings us to the end of. Thank you so much. Okay, Honorable Abdallah, you'll see the veterans out. you are discharged. No more interaction. You are discharged. Mutuke bulungi jamulaga mwebale nyo mwebale ddala. Abdallah werekera abagenyi baffe. Abdullah, this is chairman's order.
Chair, I decline.
Get out of it. You'll be court-martialed.
Now that's a candidate for
Court-martialed. This kind of
exceptional circumstances.
exceptional circumstances.
You look at his shoes.
Okay. They are black.
I want to, first of all, thank colleagues, members of the committee for attending this meeting. I want to thank our stakeholder, Council Jude Yamukama, for showing interest in this matter, and you subsequently wrote to the deputy chairman here, and we gave you a slot. Thank you for coming. We are hoping that your input will be very useful in enriching our experience of this bill. And yes, you don't have copies? We are getting more, I think. But feel comfortable. This is a committee on legal and defense and internal affairs, and the two committees have the bulk of the lawyers in the House. As you see, you have many of your senior land fellows here. So we are happy to receive you, and we expect that you'll be useful in helping us to consider this bill. With those few remarks, I now wish to invite you to take us through your report.
And, well, I had a few preliminary issues which I'd indicated, but I will just summarize them in one or 2 points. The timeline which the committee gave for us members of the public who might be interested to respond to the bill is for sure quite insufficient, and I'm afraid it might eventually constitute a legal challenge when this bill is passed. Article 38 of the Constitution gives the citizens the right to participate in public affairs, and in many countries, our equivalent of Article 38 of the Constitution has been interpreted to mean that when Parliament is enacting legislation, there should be sufficient opportunity given to citizens to make some input. I recognize that our Constitutional Court still has a divided view on that question. In some respects, the Constitutional Court has ruled that you, our elected members, do that on our behalf. But I think it's a bit of an error, and there are several petitions in the Supreme Court over whether that is a correct interpretation of Article 38. But still, I think as a matter of practicality, it would be good to give opportunity to people to weigh in. I received several, we've had a lot of debate with some of my colleagues. Many felt that the invitation is to participate in this committee were just a window dressing exercise, and they have not been able to propose. I struggled to come up with my memo very quickly, partly because I do represent people who have come from the court martial and are processing the civilian courts and are caught in this dilemma, and I felt I would be doing them a disservice if I kept quiet and didn't give this committee some perspective on a few areas. So that having been said, I recognize firstly, and I'm very happy, that this bill has very good provisions on welfare for members of the defense forces. Like I indicated in my memo, I have also represented members of the defense forces, and that's when initially when I was a much younger advocate, I never used to know that provisions of the Workers' Compensation Act don't apply to members of the defense forces. And because the Workers' Compensation Act is a law that helps to provide compensation for injuries or death in the course of duty, in the course of employment. And it doesn't apply to members of the armed forces and the Uganda police for the obvious reason that there is that assumption that when you sign up for duty in those areas, the risk is way higher than a civilian who signs up to go and to come and work in Parliament and then gets an injury maybe coming to work. Therefore, it's really very important that these provisions are there. I've liked them a great deal, and I hope they can be passed despite the other clauses we might have debate on, which I think need careful thought. But I think these are quite important. They are quite important in this bill, and therefore I've uploaded in my memo that there are positives in this bill, and that is my position. And the executive is applauded for making sure this provision is made. However, I'm only going to dwell on the areas of improvement and adjustment, the areas where I see there is need to improve. So, first of all, this bill and the parent law, the UPDF Act, have a criminal justice system built in them. The court martial is part of the criminal justice system. And the Supreme Court in Kabazuguruka, contrary to the assumption out there in the public, did not say the court martial cannot exist. The Supreme Court recognizes its existence, but as a specialized court. Now, the moment you have a court of law which administers criminal justice, there is a number of other provisions that come into play. And one of the omissions in this bill and in the parent law, the UPDF Act, is that, first of all, for instance, the Human Rights Enforcement Act, which is Chapter 12 Laws of Uganda, has never been cross-referenced and applied to provisions of the UPDF Act and even in this bill. What that means is that accused persons who are charged in the military justice system cannot benefit from provisions of the Human Rights Enforcement Act. And that is a mistake, because when the act was enacted, when the Human Rights Enforcement Act was enacted in 2019, I think there was this assumption that it will know its provisions need not apply to the court martial. It could have been an omission. I don't know what happened then. But it contains provisions, first of all, which point out that when you are trying an accused person, and an accused person complains about violation of their rights or of due process, then the court needs to inquire into that complaint and determine it. How this law operates: if an accused person, for instance, claims, I have been tortured, I was detained in Communicado, and all that, if they are charged before a military court, if they are brought before the general court martial, and they raise that complaint must first be investigated and determined. And then this law, the Human Rights Enforcement Act, creates two standards. It provides that if a non-derogable right has been violated, then you cannot have a fair trial. You must unconditionally acquit the accused. If a derogable right has been violated, the accused should be compensated with damages, and then the criminal trial proceeds. Non-derogable rights are provided for under Article 44 of the Constitution. The right to a fair trial is non-derogable. Every accused person, whether they are charged in the civilian courts or previously in the military system, they are entitled to a fair trial. Therefore, if an accused person complains that I think I'm not getting a fair trial, it is important that that question is determined before any other steps are taken in a criminal trial. And therefore, the provisions of the Human Rights Enforcement Act are intended to apply to the entire criminal justice system, and not merely the civilian system. Mr. Chair, the two members who have entered, Ms. Patience Babiwemba and Mr. Blaise Rugamba, are part of my team. They are all advocates with whom we have done work in this area. So our proposal is that this bill should incorporate applicability of the Human Rights Enforcement Act, Chapter 12, Laws of Uganda. These provisions will make it easy, no matter what happens at the end of the day, no matter what this committee decides, no matter whether this law is passed or not. Once it is passed, if we are to have military trials, whether of members of the defense forces or civilians, surely we cannot have a situation where we have a court which is outside the jurisdiction of the Human Rights Enforcement Act, Cap 12. The problem we have in practice now is that some individuals who were previously charged in the court martial could not file applications under the Human Rights Enforcement Act to the court martial, because the act specifically provides that you can only complain to the High Court or to a magistrate's court. When applications would be filed by accused persons in the court martial to the High Court would consistently dismiss those applications and claim that these matters should be addressed by the court martial, or accused persons would be advised to file petitions or to the Constitutional Court. And therefore, people who had complaints of rights violations, especially arising out of custody and similar situations, were left with no remedy. If we had had time, I would have brought over 10 rulings from the High Court about this area. Maybe someone is detained and held incommunicado. I have one such case for 4 months. And then later is arraigned before the General Court Martial. And he has nowhere to even complain. The General Court Martial says, for us, our mandate is to try you. These other things of your rights were violated. Maybe you go to the other civilian courts. For us, our mandate is to try you. And therefore, it's our request and proposal that this area should be resolved. If the military court, if the General Court Martial, the Division Court Martial, the Unit Court Martial, if they are going to have to be seized with a criminal trial of any kind, they must also be given the obligation to apply provisions of the Human Rights Enforcement Act. Once that is done, it probably could also array some of the fears and concerns that many members of the public continue to have about the quality of trials in the military system. The second point, Mr. Chair, the bill does not cross-reference or incorporate provisions of the Explosives Act, Cap 319, Firearms Act, Cap 320, and the Toxic Chemicals Prohibition and Control Act, Cap 329. There is a clear conflict between provisions of the bill on what constitutes classified stores that are ordinary monopoly of the Uganda People's Defense Forces. I will explain briefly. We have the Firearms Act permits people who are not members of the defense forces to get licenses and have firearms of a certain category. Not SMGs, not grenades, but for example, pistols. But now the schedule to the bill says pistols are ordinary monopoly of the defense forces. Mr. Chair, I submit that this could be a cause for problems. Innocent Ugandans who are licensed to carry firearms and who have firearms could find themselves being treated as subject to military law when clearly they have done nothing unlawful per se. I could have a firearm. I don't have one. I could have a firearm and I'm licensed to have one. And then I delay to renew my license. At that point, I have committed an offense under the Firearms Act. But also, I'm perilously close to this amendment, the definition of, because I'm now holding a pistol and this bill is saying that is also ordinary monopoly of the defense forces. I believe it's an error that's arising out of the omission to give consideration to the provisions of the Firearms Act on the categories of arms which civilians are allowed to hold. The same applies to the Explosives Act. We have people in construction who are doing rock blasting in mines, people in road construction. Who licenses these people with their explosives? Is it the army? And what happens? So, if we say explosives are ordinary monopoly of the defense forces, which is correct, shouldn't we specifically make provisions for civilian use of these to avoid confusion and also to avoid a possible misuse or abuse of these provisions in the future? Because as far as I'm concerned, people in mining, people who do rock blasting for road construction use explosives. And I have not seen the defense forces doing that on their behalf. So this committee needs to decide. The members of the defense forces can also guide. When I want to do rock blasting, will I request the army to do it on my behalf? Yes, the generals will probably guide us. But I propose there is a clear need for this committee to guide and ensure that there is proper reference to these laws to avoid a contradiction in the statutes. The same for the Toxic Chemicals Prohibition and Control Act. It's the same issue. There are chemicals which people have. I'm wondering whether our chemistry teachers are safe when they are carrying chemicals from Kampala and they are taking to their laboratories up country in Abim, in Kabale, in Chisoro, and then they are intercepted by security, and someone is carrying chemicals. Tomorrow, if they are taken to the military court, what will their defense be? So again, an area that requires very careful thought. Therefore, I request that the schedule, it's our proposal that the schedules on what constitutes chemicals, explosives, or arms that are ordinary monopoly of the defense forces.
Can I give some guidance?
Yes, Mr. Chair.
I should wind up and go to the house. So.
Okay, thank you, Chair, for the guidance. So we'll move to point number 4. The High Court. The High Court is generally clothed with the supervisory jurisdiction in respect of all matters of law and procedure over subordinate courts. We propose that the High Court should have supervisory jurisdiction by way of revision over proceedings in the unit and division court martials. Supervisory jurisdiction. A right of appeal to the Court of Appeal from the General Court Martial is insufficient in protecting integrity of proceedings in these two lower court martials. Revision powers of the High Court should be incorporated in the UPDF Amendment Bill in reference to proceedings before the Unit Court Martial and the Division Court Martial, because as the bill is as drafted, the bill makes those two categories of court martials subordinate, and yet they have quite very stringent powers. The next point, paragraph 5 of the memo, the Supreme Court should have the usual jurisdiction to entertain a third appeal subject to the law on third appeals in respect of trials presided over by the Unit Court Martial and the Division Court Martial. Mr. Chair, the bill as presented provides for a right of appeal from the Unit Court Martial or Division Court Martial to the General Court Martial, and then only one right of appeal to the Court of Appeal to close the matter. That is insufficient given the nature of offenses that are proposed to be covered. A person charged with murder in the civilian system gets two appeals. A person charged with murder in the military system is only going to have one appeal. That's not fair. There is very limited difference in jurisdiction between the Division Court Martial and the General Court Martial. Appeals from the Division Court Martial should equally proceed directly to the Court of Appeal on a first appeal and Supreme Court on a second appeal. The only difference in the bill between the Division Court Martial and the General Court Martial is that the Division Court Martial cannot impose a death sentence, but they can impose any other sentence. Therefore, technically, the Division Court Martial and General Court Martial really have the same powers in all respects except on the death sentence. Similarly, all matters heard by the General Court Martial in exercise of original jurisdiction should be appealable to the Court of Appeal and Supreme Court. Like for all ordinary criminal trials, that commence in the High Court. Clause 195 should be modified accordingly. There is only one right of appeal provided, from the General Court Martial to the Ordinary Court of Appeal. That's insufficient for sure. Number 8, I'm on page 5 of the memo. The tenure of members of the Unit Court Martial, Division and General Court Martial should be restricted to one non-renewable term of 7 years. In its present form, the bill's provisions on the tenure of members of the court martial do not guarantee security of tenure, which is a constitutional requirement under Article 28, Clause 1 of the Constitution for any judicial officer in order to have an impartial tribunal. See the Constitutional Court ruling in Businje Kabumba and Andrew Karamaji versus Attorney General, Constitutional Petition number 15 of 2022, which considered the practice of appointing acting judges was outlawed as offending security of tenure. Security of tenure goes to the heart of the fairness of a court and its impartiality. The bill gives contracts of 3 years which are renewable. What happens to those trials which members of the court martial handle a few days, a few weeks before that contract expires? And the standard internationally is that is not security of tenure. A 3-year contract, which may or may not be renewed, does not guarantee security of tenure. So either give one term of 7 years, that's our suggestion, or follow the path of the judiciary. I recognize the challenges in the path of the judiciary because members of the court martial cannot have tenure till retirement. It will look a bit funny. That's why our proposal was maybe 1 year non-renewable term of 7 years. The appointments of members of the court martial are still a preserve of the High Command. The proviso for consultation with the Judicial Service Commission is vague and ambiguous. It should be a legal requirement that the Judicial Service Commission will examine and vet the intended appointees with regard to their competence in matters of the law and adjudication, as well as overall suitability for a judicial role. Clause 195, Clause 2, should be adjusted to provide for the Judicial Service Commission to vet and examine nominees for appointment forwarded by the High Command. Let the High Command forward its individuals, since they are lawyers, but determining their suitability to play a judicial role, let the Judicial Service Commission at least have that no objection, since it has competence to determine who becomes a judicial officer. The current clause simply says they will appoint in consultation with the Judicial Service Commission. The consultation is not defined. It's not clear what they would do in the entire process. I recommend, Chair, that this clause should be adjusted in these terms. I'm on page 6 of the memo. The qualifications of the chairperson of a division court martial. The qualifications of the chairperson of a division court martial should also be equivalent to those of a high court judge, since this court can impose any sentence except the death sentence. Mr. Chair, it is now unusual in the civilian system for death sentences to be imposed. In 95% of the criminal trials, whether for murder, aggravated robbery, terrorism, and all, generally the practice is to impose lengthy prison terms, which a chairperson of the division court martial has powers to impose. With the division court martial has powers to impose those sentences. But the bill simply says the chairperson of a division court martial should have a law degree and then a diploma in legal practice. That's inadequate. This is a very powerful position, Mr. Chair. Similarly, other members of the division court martial, just like for the general court martial, should have legal qualifications, since in reality there is little difference in the sentencing powers of the division court martial and the general court martial. Then next point, number 12, the jurisdiction of the general court martial, should be restricted to offences under the UPDF Act, as the court martial should not be set up as a rival court to the ordinary courts of judicature under the Constitution. which preside over trials for offenses under other criminal statutes, especially the penal code. It's our case that the General Court Martial, as the Supreme Court ruled, should exercise specialized jurisdiction. In other words, it should try those matters which the civilian courts may not adequately handle because they involve some technical knowledge of the military system. That is the principle. Just like we have a tax appeals tribunal whose members are judicial officers still in a sense, but they have a little more competence in tax matters. Similarly, that should be the spirit in which the court martial should be set up to operate. Let it have jurisdiction for offenses under the UPDF Act. But when it starts going to the offenses under the Penal Code, Firearms Act, Terrorism Act, it becomes a problem. And the current wording gives it jurisdiction all over the place. We request this should be restricted to offenses under the UPDF Act. Then we point out that in paragraph 13 of the memo, it is the duty of the General Court Martial to forward a record to the Court of Appeal and eventually to the Supreme Court where a sentence of death is handed down. It is a constitutional requirement that a sentence of death must be confirmed by the Supreme Court. Therefore, clause 225, subclause 3, must be adjusted to comply with the Constitution. A sentence of death cannot be implemented before it is confirmed by the Supreme Court. And therefore, it should be the duty of the court which imposes it to forward its record to the Supreme Court for confirmation. That's an area we request for further clarification. Then clause 117A on persons subject to military law, in our humble view, clearly disregards and departs from the reasoning, decision, and directives of the Supreme Court in Michael Kabazuguruka versus Attorney General. Mr. Chair, the Supreme Court ruled in Attorney General versus Michael Kabazuguruka, Constitutional Appeal number 2 of 2021, that trials of civilians within the military courts should be only in very limited and exceptional cases. Very limited, exceptional cases. In utter disregard of this guidance and position, clause 117A instead proposes to widen the scope of coverage of civilians that may be subject to military law, instead of limiting and restricting the existing standard. The existing standard is the Supreme Court already found it too wide and asked that it should be further narrowed down. Instead, clause 117A is expanding it. I don't know whether the clause was drafted in a jest, but probably it's an error that should be corrected at the committee level. Exceptional circumstances, Mr. Chair, were defined at an international level by the Human Rights Committee of the United Nations in General Comment number 32 of 2007, paragraph 22, to mean that the state must demonstrate with regard to the specific class of individuals at issue that the regular courts are unable to undertake the trials, or that other alternative forms of special or high security civilian courts are inadequate, and recourse to the military courts is unavoidable. In other words, civilians should only be subject to the military system if it is clear that the ordinary courts are not adequate. Mr. Chair, this is the standard. Clause 117A clearly needs to be redrafted to provide for this standard. We have courts of judicature in all parts of the country. I read and respect the President's communication he made some time back about the Karamoja sub-region, but as we speak today, I know we have even a High Court judge sitting in Moroto. We have magistrates courts in Abim, in Nakapiripirit. If we ever have a situation where there is a part of the country where the judiciary is completely absent, then there could be a case to be made. That is what the international standard. Clause 117A is clearly in contempt of the Supreme Court decision and also flouts all international standards on the extent to which civilians can be subject to the military system. And therefore, lastly, it's our position, Mr. Chair, that clause 117A merely classifies certain offenses for the court martial. The standard for trying civilians has not been demonstrated at all. This is because it does not exist within Uganda, and there is no justification for clause 117A, given that ordinary civilian courts try far more serious offenses, such as terrorism and treason. This clause 117A, Mr. Chair, ought to be deleted so that we have a very nice bill looking after the welfare of members of the defense forces. It should not give this good bill a bad name. It's a good bill. I would give it 85% of this bill is very good. We have 3-4 clauses that are giving this bill a bad name, and they can end up becoming the legacy of this bill. Mr. Chair, I beg to submit. That's our position as a law firm that has been handling matters touching military justice. We thank you very much for this opportunity.
He quoted all the sections under the law as the clauses, so that should not confuse you.
Mr. Chair, those are clauses in the bill, not the current law, but in the bill.
This bill has how many clauses? When the drafting was the problem. Okay.
There is a bill. I appreciate my young brother Jude for the initiative taken for the benefit of this committee. I only need to inquire from him whether he took an initiative to inquire, because these are criminal matters which are taken under the court martial, whether you took the initiative to know how the cases should be handled before they reach court, especially when you take the line with the ordinary courts that before the criminal cases can reach court, there is always that investigation part done by police and then the sanctioning part done by the DPP. I don't know whether you took the initiative to know how best that one can be handled before the case can reach the court martial, most especially when to deal with those exceptional circumstances. Who has to determine which case is exceptional to appear before the court martial? Thank you.
Law Society, if I have not mistaken.
No, I'm not representing Law Society.
Yeah.
I came in my individual capacity just so we don't cause problems.
All right. I appreciate your submission. When it comes to clause 117, which you have recommended, that if military court, if the civilian court, the other usual courts are unable to handle cases which are being admired to be taken over by military court, you have recommended that you wouldn't support it, but to a minimal extent, you would recommend to support it. I'm of a view of inquiry from you. What if you had recommended for deletion than leaving a minimal gap for handling it? What is in your view? Then I need also guidance. We are having 3 organs of government: the legislature, executive, and the judiciary. Which organs are supposed to work independently? Why, in your own opinion, why would you support the 80% of in support of the court martial taking on cases, no exception of the civilians? Because in your own submission, you have only supported that the civilians only must be exceptional case. But if with the military you support it, 80%, to give this bill a good name. Yes. You will answer. So what I needed to know, why should the executive that houses UPDF, police, to compound up with the state, why should they have any house within the judiciary? What would be, in your opinion, as a guidance to this committee? Would you support it? I don't know whether I'm clear.
The last bit I've not understood.
Let
Go
me
to the
come
first
again.
one and the second one.
If UPDF court martial is granted the house,
We had earlier accepted the Uganda in the committee, so you can use both.
maybe I would try Lusoga. If UPDF and court martial is granted the room in the judiciary to carry on the role, the would-be work of the judiciary, what would be in your opinion? What is your opinion? Would you support court martial to be housed under judiciary, yet it is an entity that lies in the executive? Maybe that one may come out clearly. Thank you.
Maybe let me try to creating a division within the judiciary. For example, the High Court, like you have anti-corruption, like you have commercial, or a division within the High Court that can take care of cases which we are talking about. Are you talking of something like that? Because we need to understand you. I'm sure even the witness would want to understand what you are saying.
My MP, Tebandeke makes the proposition that the UPDF is under the executive. If we create a court martial, we shall be granting the executive an in-house judicial arm. And his question is, why should we do that?
Actually, you have made it more clearer. And in no, in your own opinion, Council, what would be your guidance to this committee? Should this committee recommend court martial, which is an entity under UPDF, which UPDF is under executive, to be housed within the judiciary?
Thank you, Honorable Tebandeke. Honorable Keyo.
UNEB examination is held somewhere around Matuga when he's going to Lira, and then he is accused. I wanted really you to expound on this, because the chemicals and under Chemicals and Toxic Chemicals Prohibition Control Act, they are specific. Equally with the explosives, we have commercial explosives. I think this parliament did enact that law, and it gives exceptional. So in your wisdom, do you think that there should be a clause, or we should give an explanation on the explosives, and then even the type of the pistols, because even you talk of pistols, but then I wanted to pick your opinion. If I illegally got a pistol and then I misuse it, would I be a candidate for court martial, or I would be a candidate for this civilian court?
Thank you.
That is the area.
Thank you, Honorable Keyo. Honorable General Mujira.
But I need a clarification on his recommendation that the court martial should restrict itself to trial of the offenses that are not provided for in the penal code. I'm aware of the provision of the penal code, I think section 2, which limits the jurisdiction of our courts, because it does not grant extraterritorial jurisdiction save for cases of treason and misprision of treason. Now, I want you to advise on situations where you would have a military personnel who has committed murder in an operational area, like in Somalia, and we have to try him. What would happen if we just restricted ourselves to only the offenses provided for in the UPDF Act?
Honorable Lumo.
Jurisdiction over all matters. And I want also you to look at people who have been arrested in Uganda, like Jamil Mukuru, for example, having led a certain rebellion group. And that person is not being taken to court martial. And others who are civilians arrested on different offenses are taken in the court martial. Don't you think that the High Court, with its well-qualified judges, can handle all matters except those which are so exceptional? But those exceptional cases should be given a section of how they become to be exceptional cases, to be tried in the court martial. I want you to take us through that line. Thank you very much. Just a small thing for him. There is what we call International Criminal Division. Can't it handle International Criminal Division? Don't you think, Council, that International Criminal Division can as well handle matters like General Megira talked about, for example? Don't you think? Don't they have capacity to do that, in your wisdom? Can't you also take it?
Okay, now, Patrick. My first concern was in regard to time management, because earlier on he had raised a red flag that probably would handle this very fast and join the others in the chamber. But Mr. Chairman, sir, if that is the case, because really this memorandum is very elaborate, I want to thank Councillor Jude, with whom I studied at the law school. Thank you so much. It will really enrich us as a committee. But something small with me, because honorable members, in summary and in my understanding, this bill is dealing with civilians to be tried in the general court martial upon commission of certain offenses. But there is somewhere where you said, where you talked about the monopoly. Just on page 3, where you talked about, of course, the monopoly of the defense forces in regard to the ammunitions. Now, honorable members and Mr. Chairman, in my understanding is that when a civilian is permitted by license to hold a firearm, once they commit an offense, they should be tried in the civilian court. That is my understanding. But when you hold it unlawfully, then you will be taken to the general court martial. Now, Councillor Jude somewhere is saying that there would be instances where a civilian who is holding it legally by license would be charged in the general court martial. If you can help me bring out those instances, if any. Thank you.
Can I have colleagues who came in later? The written text really is self-explanatory. However, as you realize, this whole conversation relates to one issue: trial of civilians in the military courts. That's the only controversy in my view. And I think if we can zero and have a real conversation about that, we might make progress on this. Let us look at what did this case say. 15, your clause 15 of your submission, the Kabaziguruka case. You see, it would be better, because you see there were several judgments. And when you just say the judgment said this, you know, you run the risk, which I see many members of the public, you know, running, this is the judgment, this is the judgment. We need to go to the specifics. Which judge said what on this particular point? Because if you do that, then you narrow the point of interrogation. What did the judgment say? And if we are implementing this judgment, what are the confines? So, as you do realize, many judges had different reasoning, though they came to the same conclusion. And you say the trials of civilians within the military courts, and I'm on page 7, should be only in very limited and exceptional cases. That's what you say. If we can go just to the judgment itself, because we are going to interrogate those judgments and say, this is what exactly the judges say, or this particular judge said this on this. It will help us, other than having a general conversation, trial, civilians, trial. Number 2, I want you to help clarify on the principle of aiding and abetting. Assuming a soldier has committed a service offense under the UPDF Act, but has been aided and abetted by a civilian. Because the general principle you and me know about, if somebody aids and abets, is equally guilty like the principal offender. Do we have them tried parallel? The soldier being tried, if he has committed an offense under the what? The UPDF Act. Tried in the court martial, then this civilian who has aided and abetted goes to a civilian court. Do you have 2 parallel systems trying a person or different person on the set of the same facts? Third, I think. And I'm glad that Attorney General is here. He should consume this. He's not appearing, but he should consume it. There is a suggestion made by Jude in his presentation that other than using the word in consultation with the Judicial Service Commission, can we give the Judicial Service Commission some wider role in vetting the nominees by the High Command for this position? So that, because since we have not defined this consultation, what does it mean under the law? But if the High Command forwards the nominees to the Judicial Service Commission, and they are interrogated as to their capabilities and the appreciation of the law, since they are going to perform judicial functions, other than saying any consultation. I think this is, to me, it is a brilliant idea which we can consume to give the judicial service a more role in appointing judicial officers. And by the way, we need to understand this. It is not about civilians.
Lumu, you are the problem here.
Okay. And I think we need to make this clear, colleagues. The court-martial should not be about civilians. Because even soldiers need justice. They need justice. And they should be tried professionally. So we are not here to protect interests of civilians. We are protecting interests of everybody who appears in the court-martial. No, this is about the court-martial, and the court is a different matter. So, you come from Osiris. So, if we can, the Learned Attorney General can really think about this and discuss it with his minister to say, can we have a wider role of the Judicial Service Commission other than in consultation? To me, I'm convinced actually that that is the way we should be moving, but we shall discuss it later. About Jamil Mukulu, I think this was well explained yesterday, colleagues. The International Criminal Divisions Court is a specialized court, but under the Rome Statute. And it is set up like it is an act of the ICC. So Jamil Mukulu is not necessarily under our jurisdiction. No. Because he's accused of committing crimes that some of them are not provided for, like genocide. And the genocide is maybe not only in Uganda, but also in Congo, wherever he was operating from. He's being accused of war crimes. Wherever he's said to have committed them from. So, the International Criminal Divisions Court is not necessarily one of our courts of judicature, but the Rome Statute provides that if you want to try them, other than them being tried in The Hague, you must do this. That's why, even at high court level, they sit 3. At high court level, they sit 3 like the apparent what? Court. So we need to distinguish that Jamil Mukulu, because I see it every other time it's coming and so on. Mr. Chairman, I think that's all from me.
Thank you, Chair. I'm happy that you made that. This is on paragraph 5, honorable colleagues, and it's on page 5, which is paragraph 8, on the tenure of the court martial. Of course, Jude, as counsel and advocate of High Court, considers what the Constitution says about independence of judiciary, where tenure, security of tenure is very important. Now, you propose 7 years, which ordinarily would be good, but this is a special court. You cannot have a soldier at one rank for 7 years. Well, we are putting it to him. So would you...
You can. It has happened.
Well, then...
Are you saying it is wrong?
Well, so I want to interrogate you further on this. What would the problem be if it were 5 years? What the problem would be, because the other thing we encourage, honorable colleagues, the other thing we encourage here is speedy trial. Okay? So why then prolong the tenure if the intention is actually to have fair but also speedy trial? Again, when we have also provided avenues and opportunity to appeal. Thank you.
Mr. Chairman and honorable members, thank you very much for this opportunity. I will not speak much. I have a huge background as to how we got here, because it is a matter that started in 2005 with the siege of the High Court. And that's when we started mooting the idea of having the court-martial off our books. When the Supreme Court made what they call advisory opinions, before I even go to the reasons why and how they got there were different options proposed of bringing the operations of military justice within the context of the judicial functioning in Uganda. One of the proposals made, especially through the lead judgment of the Honorable the Chief Justice, was we could create a division in the High Court, just like we have a division in the High Court that handles corruption and other issues. And the reason was to detach the military from the administration of justice, which is a specialized function, not just on technical grounds, but even under the doctrine of separation of powers. And I missed the Attorney General yesterday. He would have explained to me why, of all the options suggested by the Supreme Court, they opted for what we see here. That's why the Honorable Alternate Chair is talking about, stating what he has just stated. 5 years, 7 years, 3 years, it could even be 10 years. As long as somebody you're calling a judicial or quasi-judicial officer has prospects of redeployment, promotion, punishment, and so on and so forth, you are not creating an independent, impartial court. And to me, that's the crux. It has nothing to do with whether you're trying civilians or military officers in a military court. The nature of the establishment of the military cannot guarantee a fair trial. It cannot be an independent court within the description, within the confines of the Constitution. You cannot talk about security of tenure and you're talking about 5, 7, or even 10 years. Why not 20? The moment the person you're choosing as a judge, quote unquote, is a military officer expected to abide by a certain code, Honorable Chair and Honorable Members, you're wasting time. You are not going to create a court that conforms to the tenets of a fair trial before an impartial and independent tribunal or court, by whatever description. And I want to agree with the MP from Bugwe, my immediate neighbor. I've forgotten his name. The beauty is that under the rules we refer to members by their constituencies. Yeah, like Busiro, which some people who didn't go to school cannot pronounce. Mr. Chairman, the discussion must go back and I wanted to agree with him to the extent whether somebody is a soldier or not, he's entitled to the same privileges once appearing before a court. It must be independent. The second element relates to this thing of aiding and abetting. And I want to relate it to where they said someone is in illegal possession. Legal versus illegal. I mean, I have a licensed gun and someone has just stolen a gun, how we should handle them. One, this aiding and abetting is a matter that must equally be decided independently. Here you are, you're having somebody, a prosecutor in the army, who decides whether to charge me with that offense. He decides, and he's not independent. You have an office of DPP, and this was touched again by the court, a Director of Public Prosecutions, whose function, among others, is to avoid abuse of judicial process. But supposing I am Noop, and this particular officer is inclined to think I must support NRM, as you know how they treat themselves. They feel they are part of the NRM. This officer will charge me with aiding and abetting. Those are ingredients to be proved. Now, the person who is preferring the charge is not independent, like we created office of DPP, presumably independent. Two, the court before which I am appearing is equally not independent, because the judge or judges, whatever their description, expect promotion, expect deployment, supposing he makes a wrong judgment and is posted in Karamoja. So, the Karamoja I'm referring to is where they are saying go into cattle wrestling, and I do not want to impute bad motives on what happens in Karamoja there when you are deployed there. So my view, Chairman, is as we pursue the area of discussion with the government, which I'm amenable to, we must also interrogate why we cannot go for the other options suggested by the Supreme Court, as opposed to this one, because this one is going to take us back into the same conundrum. I want to thank you, sir.
Thank you. Finally,
decision and directives of the Supreme Court. Can you help us, from your knowledge of the law, of these three parameters, reasoning, decision, and directives, which one ranks higher, if you are ranking? Yeah, just from your knowledge and experience of the three, which one it's more final? And then, I want also to pick your mind on this. My understanding of the law is that there is an offense of murder or aggravated robbery. That is the offense. And the ingredients which are not provided in this act remain the same. If I can recall, death unlawfully caused with malice and etc. So both the military court and the civilian courts, if you are trying the offense of murder or aggravated, you use the same standard. Under our laws, Article 21 or something, every person must be treated equally. Can you help me marry the equality before the law? When now you decide to send one for the same offense, because it's murder, what the act, what the bill is trying to propose is to create different ways of committing murder. That's what I understand. But the end result is that you have committed the offense of murder. With this one, they're saying, because you use a gun that was not licensed, that's why we are taking you here. With the other one, they're saying, because you use a gun which was licensed, that's why you are going to civilian court. Does that speak to that provision of the Constitution of equality before the law? And then, I have heard that there are scholars who have done some studies on military justice and something. I want to use the one I know. In Uganda, there appears to be provision for Sharia law, okay, which is not being enforced. My presumption was, for the military justice system to work, there must be two legal regimes. The whole set of either the Constitution running with all the supportive acts of what we call military law, and then a whole set from the Constitution flowing of what we call civilian law. So for you to take civilians to cross into this rim, you must have two justice systems. Now, I thought the basis of a military court, if it exists, was that there were a certain set of offenses that can only be committed if you are a military officer. For example, you refuse to attend parade. The general knows others. You refuse to attend parade in the morning. How do you get disciplined? Should we waste your time to take you to a magistrate's court? No. So we deal with you internally under because there is a code, there is a set around that. You are deployed and you abscond from your duty, you go and enjoy other things, and then you are found. So a civilian ordinarily would not be.
Jonathan. So we will proceed written text. Yeah. If there are issues that you think you cannot canvass here, we can receive that text tomorrow. Because the House was adjourned for only 1 hour, and at noon we are supposed to reconvene. Yes.
Council, I'm tussling in my mind to get the explanation of High Command as being used in the bill. I'm not getting it. Yet it is subjective to recommendation of the chairpersons and other people to sit on at the division level court. In your own opinion, have you come across the explanation of high command, that terminology, high command? I would like to know, it is confusing me. Where do they get the moral authority to second the legal officers?
You want to clarify, folks?
Certainly be taking up the proposal to send an additional memo to highlight some of these in details. As you recognize, I only had an hour or two to put this together. The High Command is an organ of the Defense Forces and it's provided for in the law. And that's why it's the highest decision-making body in the army. So that should be quite clear. I do agree that there is a legitimate concern, which was slightly beyond the scope of my memo, regarding the separation of the investigative and prosecutorial roles within a justice system. In the military, these two ultimately are fused. And when a person is charged, it becomes very difficult to separate the system, the members of the system who are carrying out the investigation, the members of the system who are prosecuting this individual, and the members of the system who are now performing a judicial role. And that is why it's an area that requires careful thought. But the overall theme, Mr. Chair, which I need to explain, is that all professional armies world over do have court-martials. Okay? It's not a unique Ugandan situation. And the purpose why the military system must have a court-martial is partly because even these normal offenses like murder may occasionally need input of people who have an experience of combat. For instance, if a soldier is armed and is attacked and kills 20 people, for us the civilians we may say, no, he has killed 20 people, that's a murder, he has killed them, he must be charged. But the colleagues may say, no, this was self-defense. These people were going to kill him and he had the option to kill them first. So there are contexts like that. For instance, I had a view about a police officer who was killed in a mob in Uganda, and I felt he should have killed more of those people first before he was killed. But you see, those are operational issues. And therefore, there are these crimes which may be committed in the context of, which require some operational insight on what goes on at a front line, in a combat zone. And that is why all modern armies have a level of military courts. Why ours here is becoming controversial is because of, one, this idea of trying to bring in civilians all the time. That's the biggest problem. Then secondly, setting it up as a rival court to the civilian system. It's not, instead of supplementing, it appears to be suppressing the civilian system. Those two are the unique Ugandan issues which we need to look at. One of the honorable members asked why I'm giving the bill 80%. This bill, as I indicated, is way more than this clause about civilians and the military justice system. And like I said in my memo, a large part of it about the welfare of the defense forces is long overdue. I have done work for representing members of the armed forces who are injured, who are amputated, and they are in Mubende, in the hospital, and that is all. And they don't know how to move on with the rest of their lives. So I think it would be very unfair for this bill to get a bad name because of these 4 or 5 clauses which we can work on and which this committee can work on and or remove. The idea about how a military court operates is only getting controversial because of that idea of when you bring in civilians. For us civilians, we look at things, of course, also with the civilian eyes. And the standard of justice we expect and the kind of offenses that are going to be tried makes it very, very critical to comply with a very, very, very stringent standard. That is why in my memo, when I point out, someone gave an example of the offense of murder, you will note, Mr. Chair, that in my memo, I'm insisting that the right of appeal that exists for ordinary murder trials at the High Court, which is 2 appeals, Court of Appeal and the Supreme Court, should be replicated. Because if somebody is tried for murder before the General Court Martial, the bill says they have only one right of appeal to the Court of Appeal, and it closes there. That is obviously not fair. Where will be equality before the law will be coming into play, because both people are charged with murder. It can't be that a civilian charged with murder should have 2 appeals, and a soldier charged with murder can only have a right to 1 appeal. It simply creates a system that is not fair. Regarding this subject of explosives...
And Jude, how
yes,
do you
please.
resonate that with the fact that under the Constitution, one cannot be executed except if there is confirmation by the highest court?
Thank you, Honorable. I did point that out specifically, that a death sentence must be confirmed by the Supreme Court. Yeah. On the subject of explosives, chemicals, and pistols, as I indicated, they are simply listed in a blanket manner as being ordinary monopoly of the defense forces. It is not indicated anywhere in the bill whether there is any other individual who could access them without becoming subject to military law. And therefore that leaves room for interpretation, which could be problematic. That applies to explosives generally, it applies to chemicals, and it applies to small firearms, pistols, and that category. The example I gave was if somebody has a firearm and his or her license expires, they are technically holding it now contrary to the law. So if they use it to commit an offense, according to the bill, they will be under clause 117A, will be triggered. They will become subject to military law. And I think that is quite beyond what might be, what the drafters could be having in mind. And that's why I insist about the need to cross-reference the Firearms Act, this law on explosives, and this other one on prohibition of chemicals and toxic chemicals. Because it may not be an issue now, but as I know, honorable members here know this far better than the rest of us, you legislate for the future. You don't only think about the current challenges that we have. We may have more difficult challenges in 5 years, 10 years, over some of these provisions. Offenses in the UPDF Act, it's my understanding, Chair, that a specialized court generally should handle offenses from a specialized statute. The moment you have a specialized court and you give it ordinary jurisdiction over the entire criminal justice system, all the offenses under the penal code, you create these challenges that currently exist. Why? For instance, we are talking about the right of appeal. You are charging somebody with murder under the penal code, but the person is being given only one right of appeal. The one who is charged before the High Court is entitled to 2 appeals. The offense of murder, obviously, is one which has to exist in a military court. There is no doubt about it. Court martials world over, members of forces get indicted for the offense of murder in some cases. And the standard has to be who is being covered. And like I emphasize, the problem that we are getting, our discomfort about these provisions largely continues to operate because of how, one, you operate them to civilians. Then secondly, you cannot lock in only one appeal for a person charged within the military justice system. The civilian courts under the Constitution should still have some level of oversight. And that oversight becomes the fair way of letting the court martial handle offenses touching members of the defense forces, but also members of the defense forces are entitled to quality justice. And therefore, the civilian oversight should not be disregarded or undermined in that context. The issue of the ICD was handled so...
Councillor Jude, colleagues, I have heard the bill. I don't know whether you also heard it.